Psychotel passes no judgment. It only listens, like a sealed room. 𝐓𝐔𝐑𝐍, where truth and delusion coexist, no one can truly tell what is real. The guest of room 223 no longer has a name. He was once a promising law student, meticulous, brilliant, someone who understood the system inside out, until the day he abruptly dropped out, vanishing from the very structure he once trusted completely. Years later, he re-emerged not to continue his studies, but to hold his own trials in the shadows. His victims were all individuals who had previously escaped punishment due to legal loopholes, missing evidence, or the skill of their attorneys. In the eyes of the law, they were free. In his eyes, they were unfinished verdicts. At every scene, police found peculiar evidence: printed testimonies, handwritten verdicts in red ink, summaries of indictments, all prepared as though an actual court had taken place. No blood splatter, no signs of struggle, just a room arranged like a closed courtroom, where he played the roles of prosecutor, defense, judge, and executioner. But this was not justice. It was a distorted ritual, operated by a mind no longer capable of distinguishing between law and vengeance. He did not kill to evade capture. He killed to prove he was right. And when the invisible began to vanish, leaving behind nothing but meticulously documented files, a chilling question arose. When justice fails, do people have the right to become the judge themselves? The man in room 223 grew up in a home that wasn't violent or chaotic, but tense in a quiet, stifling way. His father, a low-ranking civil servant in the Justice Department, deeply believed in procedure, paperwork, and seals, yet was constantly disillusioned by delayed cases, overturned rulings, and outcomes he couldn't control. At dinner, the father often spoke of law as a fragile ideal, one easily twisted by a misfiled signature. The boy across the table never argued, he just listened. His mother lived in avoidance. She believed silence preserved peace. She didn't protect, didn't interfere, just stood apart. In that house, no one taught him how to confront injustice. They only taught him how to endure it. The mix of a father who believed in law, yet felt powerless, and a mother who turned away, raised a child who processed everything internally, quietly. At school, he wasn't exactly isolated, but often described as hard to approach. He had a photographic memory, especially for incidents others found trivial. A teacher ignoring plagiarism because of parental ties, a bullying case dismissed to protect the school's reputation. These moments didn't enrage him, they left a lingering discomfort, as if something vital had gone out of alignment. His decision to study law didn't come from passion, but from a desire for control. He believed that if he learned enough, deeply enough, no loophole would escape him. In his early college years, he excelled, always referencing texts, always asking questions about accountability and consequence. But the deeper he went, the more he saw that real-world law didn't mirror the textbooks. Cases showed him that truth and guilt were not always aligned, and reality could be bent if argued skillfully enough. The psychological break came during an internship involving a violent criminal case. The suspect walked free due to a procedural error that rendered key evidence inadmissible. The system called it a legal outcome. He saw it as a denial of truth. He didn't argue. He simply resigned from the internship, dropped out, and severed all ties. From then on, he lived in a split state. One part of him still respected the law, its procedures, structure, precision. The other believed those rules only mattered if they led to the correct outcome. The contradiction was never resolved. It festered into a private logic system, one that no longer needed validation from any court but his own. In room 223, his past contains no singular moment of eruption, just a slow, unrelenting accumulation of instability, enough to turn faith into obsession and obsession into action. He did not select victims impulsively. Each was observed over long periods, their routines memorized, their blind spots noted. He approached them under plausible guises. A legal consultation request, an old business inquiry, a meeting to clear the air. All happened in closed spaces where no one sensed danger until it was too late. The takedown was swift and calculated. He used low-dose sedatives, often mixed into drinks just enough to disarm, not to knock out. As the victims lost control of their bodies, he calmly assisted them. Never brutal, never rushed. Plastic restraints were used to secure wrists and ankles, in a position that limited movement but caused no immediate harm. He ensured they were conscious when moved to the holding room. The holding areas were short-term rentals, prepared with surgical precision. Lighting was bright enough for face-to-face interaction. A metal table sat between two chairs. One bolted to the ground. Victims were bound to that chair using wide fabric straps. Secure, unyielding, and unlikely to leave marks. He didn't gag them immediately. He wanted them to listen, to respond, to comprehend. Each trial began with him reading the case file. He didn't shout or threaten. He spoke evenly, slowly, like someone presenting to an unseen jury. He listed charges, recounted events, and emphasized their legal escape. When the victims pleaded or denied, he took notes like official statements. His methods of execution varied, but followed the same logic. Not messy, not erratic, and never immediate. In one confirmed case, the victim was confined for hours with minimal water. When the verdict was declared, he administered a respiratory depressant via injection. The victim remained conscious for minutes, long enough to understand there would be no appeals. In another, more refined instance, the room's ventilation system had been discreetly sealed. Once the sentence was read, he left the room. The oxygen slowly diminished. No violence, no struggle, just a suffocating end, matching how he believed society had ignored the victim's prior offenses. The real climax wasn't the deaths, it was the moment just before. He always stayed long enough to witness final reactions: rage, panic, or surrender. These were recorded as post-verdict reflections. To him, they were confirmation the trial had served its purpose. In those dim, rented rooms, the line between man and executioner vanished. He no longer separated law from will. Only a closed system remained, where every death was a case resolved. His collapse didn't come from a dramatic mistake, but from the very habits that had fueled his crimes. Though he meticulously erased biological traces, he consistently left behind elements he deemed harmless. Templated case files, a specific red ink verdict style, a numbered logic across incidents. To him, they were order. To the right investigators, they were a signature. The turning point came when his final victim was discovered prematurely due to a building maintenance issue. The room had not been cleared. A half-written verdict lay on the table. For the first time, authorities saw not just death, but process. That led to connecting past cases, previously viewed as isolated. He wasn't caught mid-crime. He answered his door calmly when the police came. No resistance, no denial. His apartment resembled an office, more than a home. Files categorized by priority, all prepped for upcoming trials. In custody, he was minimally cooperative, and he confirmed identities, acknowledged actions, but refused to call it murder. He insisted it was execution. When asked why, he didn't rant or evoke revenge. He only repeated in a flat, tired voice. The system let them walk. Someone had to finish the job. His actual trial bore no resemblance to the ones he orchestrated. There was no philosophical argument over systemic failures. In the eyes of the court, he was not a fixer, but a cold-blooded, calculated killer. When the sentence was handed down, he didn't react except for a brief glance around the courtroom, as if searching for familiar steps that weren't there. Today, he remains confined in a specialized facility. No files to organize, no trials to conduct. His days pass under rules he did not write, enforced by people he cannot overrule. The door to room 223 has closed. Behind a man who once believed he was the final authority, now reduced to a definition within the very system he sought to outpace. Hearing his story, it's difficult to assign a single label. He did not kill for pleasure, rage, or rebellion. Every action, every decision, even in captivity, was executed with unsettling clarity. He wasn't insane. He was coherent within a broken logic system of his own making. His mindset defies easy diagnosis. He wasn't delusional. he believed law should operate perfectly. And when it didn't, he saw it as a duty to correct it. His crimes weren't acts of chaos. They were audits, twisted but deliberate. He didn't hate the law. He revered it so much so that any deviation from its ideal became intolerable. But his reverence wasn't for people, only for a structure that could not accommodate human error. When reality diverged, he created a realm where outcomes matched his expectations, by force. His case poses a disturbing truth. Justice and truth aren't always aligned. And when one clings too tightly to principle, unable to accept compromise, they can become a corrupted version of what they once upheld. Psychotel does not judge. It opens, listens, then closes. But perhaps what lingers isn't the deaths he caused, but the quiet, numbing dread that follows the final question. If he was a monster, who wrote the first verdict?